humanitarian law has become a term of art, a term that only sets the rules. This is when you can kill and when you cannot kill.
Welcome to Rethinking Humanitarianism, a show that explores the future of aid in a world of rising crises. I'm your host, Tamam Al-Audat, CEO of the New Humanitarian. We live in a world where we can watch a country brazenly bomb healthcare facilities and commit genocide, and it's broadcasted straight to our phones. Then we scroll down just a little further and see how another country breaks the UN Charter by invading its neighbor in a war of aggression. It's clear that our rules-based multilateral policy systems and structures of international law are not working. But what can we do about it, as countries, as humanitarians, or as concerned citizens? To take a critical look at those systems and structures and to ask if there is a better way forward, we are joined by three highly decorated legal scholars. First, we have Neve Gordon, an Israeli professor who has written extensively about the Israeli-Palestinian conflict, the bombing of healthcare facilities, and coined the term medical lawfare. He is a fellow of the British Academy of Social Sciences and a professor of international law and human rights at Queen Mary University of London. We are also joined by Michael Kwame Addo, professor at the University of Notre Dame and international lawyer with expertise in international human rights law and international business policy. The UN Human Rights Council appointed him in 2011 to join its working group on business and human rights, which he currently chairs. And finally, we have Oona Hathaway, a professor at Yale Law School, who has been a member of the Advisory Committee on International Law for the legal advisor at the U.S. Department of State since 2005, and a member of the Council of Foreign Relations since 2011. She is currently working on a book titled War Unbound, Gaza, Ukraine, and the Breakdown of International Law. If you have any questions or comments, stick around for the credits to hear how to reach us here at Rethinking Humanitarianism. Oona, Neve, Michael, thank you very much for being here with us today.
Thanks.
Thank you for having us.
We're talking today about international law, particularly about international humanitarian law, its role, its limitations, and whether it still works in our day and age now that we've witnessed the genocide in Gaza and the continuous war in Sudan, the one in DRC, and obviously Ukraine, among others, in the past few years, where IHL has not functioned as advertised. Can you give me a brief overview of what does IHL look like today? And I will start with Oona.
So hard to say that it's the best of times, but I've been spending the last several months going back in history and thinking about our current moment in the context of the arc of history and efforts to regulate war beginning in the 1600s. So when I say history, I mean going back pretty far. And the struggles we have today in trying to regulate and control and manage war are obviously far from new. And in many ways, the rules that we have now are far more robust than they've ever been. So Hugo Grotius, who many people celebrate as the father of international law, he thought there was basically no limits on war. War could be used to resolve disputes between states. His idea of a just war was any war that was fought for a just cause. And he placed very few limits on what states could do, and that states could slaughter civilians with impunity. And that was true for hundreds of years. I think it's worth starting with what is the legal framework? I mean, we have much more robust rules now that aim to contain not just useless violence, because the sort of earliest rules were really efforts just to contain useless violence, so don't kill wounded soldiers, equal treatment of soldiers, basic limitations on really excessive violence that wasn't very useful. We now have rules that aim to regulate useful violence against civilians. So the principle of proportionality, for instance, which says like even when you're aiming at a legitimate military object, you can't use force if the effect of civilian objects is going to be excessive in relation to the military aim that you're seeking. So in some ways, we have these extraordinarily robust rules, at least in historical perspective, and yet they're obviously not working as intended. So the question is, are they not working at all? I think they're working some, but they're certainly not living up to their promise. And the struggle for international lawyers, I think, is, do we just throw it out? Do we give up, given that we're facing, over 60,000 civilians killed in Palestine, tens of thousands killed in Sudan, many thousands killed in Ukraine, just in these recent conflicts, extraordinary suffering that we see around us and that we read about every day. And yet, what looking at history teaches us is that things could be far worse. I don't think that's a comfort, but that is a reality. Things could be much worse.
Michael, is it improvable?
Well, I hope so. Otherwise, there's no point being a lawyer at all. Now, I should say I agree with Oona about the purpose or the value that a legal framework serves. But sometimes the law itself turns out to be the problem because it tends to constrain the frame beyond which human beings can implement it. And I think the original purpose to regulate senseless violence was a good one and probably should continue to drive it. But that's exactly the problem in itself because humanitarian law has become a term of art, a term that only sets the rules. This is when you can kill and when you cannot kill. The idea that a whole different regime says killing is wrong, i.e., international human rights law says killing is wrong, doesn't even feature. So you get in this term of art permission to kill. And we forget that. And also, that is a concept that defines an exceptional framework. It is a framework of war that where reason is not the norm. In other words, we're only doing this because we need to survive, and therefore granting ourselves the need to do what we need to do. So that if at some point we move, and a lot of scholars have tried to move international humanitarian law into the framework of international human rights law, and saying the overriding purpose of this is the protection of all human beings, presumably pushing the limits to say maybe the use of force should really not be an option, which I suspect nobody will buy. But of course it could be improvable, particularly if we're driven by the original purpose to try and remove violence from the human endeavor. I know it's a bit of a higher purpose, but once we do that, we can then begin to construct rules that really take the use of violence to the most extreme situations where there's no other way to conduct any particular objective but war. If that's the case, then we can improve it. But at the moment, it looks like we go to war and then we play off with what the rules say. And for as long as there are lawyers constantly reinterpreting, the system goes backwards rather than forwards. And I do mean to support Oona's point that we do need the rules. If you think about where we've come from and how far humanitarian law has helped, that is a great thing. But to the question whether this is good enough, can we do better? It's not good enough, and we can do better.
Neve, you and your co-author, Nicola Perugini, coined the phrase medical lawfare in relation to Israel's attack on Palestinian healthcare and their legal justification. Could you elaborate on this, since I think it is a very good example of some of the pitfalls in our current international law, specifically humanitarian and human rights international law?
So our medical lawfare article came at the heels of another article, which was about hospital shields and the limits of international law, where we actually looked at the history of hospital bombings from the first bombing in 1911 by the Italian regime in northern Libya against medical units there, through World War I, through the colonization of Ethiopia, World War II, the Vietnam War, the Korean War, even before then, and until today. And what we saw is that often the actors that bomb medical units use the law itself to justify the bombing, because the law itself has a series of exceptions saying that when a hospital is used to shield combatants or an arms depot, or when the hospital is used outside its humanitarian mission to carry out acts harmful to the enemy, then, provided certain legal principles, the hospital becomes fair game. And what we saw in our studies, and we looked most closely on Syria. I have an article that deals only with attacks in Syria, and then on the different cycles of war, and finally the genocide in Gaza, how different actors deploy these exceptions within the law. They own the bombing, and they say the bombing was legitimate. And while certain civil society organizations will say that they're perverting the law or they're instrumentalizing the law, we have to remember that legal work is interpretive work. And they're interpreting the law and using the tools that are within the law to interpret it in such a way, and basically creating a situation where the law itself becomes a tool of legitimizing medical units and staff.
I think it is important to note that Israel was bombing healthcare facilities as well as halting Gaza from availability of clean water long before October 7th. And your article goes back as far as 2008 at least. And Neve, you're working on creating a binding international law instrument that prohibits the targeting of healthcare facilities under any circumstances. Can you tell us about what is it they aim for and how likely is it?
One question that interests me is the harm carried out when attacking medical units. And there has been really no study that looks at what is the kind of harm that happens when you damage or destroy a hospital, and what is the kind of harm that you produce when you damage or destroy a whole medical system like Israel has done in the Gaza Strip in this genocidal war. And what seems to me is that if we change the lens of harm from looking at harm that is created at the event, which is what militaries do and often lawyers do, and put on a doctor's lens or epidemiologist lens and looks at the harm that is created when attacking a hospital and maybe ruining a CT and there can no longer be imaging in the region, or maybe killing the only oncologist in the region, or the only cardiologist in the region. What is the kind of reverberating harm? And it seems to me that if we carry out this analysis, at least that's my hypothesis, is that it's a multiplying force of harm that is not unlike a weapons of mass destruction. And if it's like a weapon of mass destruction, what do we do with weapons of mass destruction? What do we do with chemical warfare or biological warfare, and also with indiscriminate warfare like landmines, where oncological patients will no longer be able to receive treatment because the only oncologist was killed. And to be honest, that is exactly the situation now in the Gaza Strip, where we have dialysis patients that can't get treatment, where we have oncology patients that can't get treatment, even after a ceasefire has been called, because there is no knowledge there to give the treatment, and there is no medicine, and there is no ward, and so forth. And the reverberating harm is so large that it's like a weapon of mass destruction. So what we're calling for, or what I think we need to call for, and particularly humanitarian organizations who send their staff to work in these hospitals and who are courageous but are endangered, they need to call for a total ban, not only to say medical units are not a target, which is the campaign launched by scores of organizations.
Yes.
Of course, it's not a target, but we should say that it is illegal regardless of the situation and regardless if non-state actors are in the hospital, non-state warring actors are in the hospital, it is illegal to bomb it. And we can also say it using the principle of proportionality, because if it is a weapon of mass destruction in terms of the harm that it produces, then we cannot apply the principle of proportionality on it, regardless of who is in the hospital.
A few years back, I would be able to give you a few examples where IHL actually worked. I'm struggling more and more. Has it ever worked? Can you, like, hand to heart say, this is an example where IHL worked as it should be?
I think the idea of military personnel being aware of this is a first step of it working. Training does take account of IHL, and that is a great working. I mean, so then they get into the field, and then in Malai or wherever else, they misinterpret it. It's a shortcoming that comes from a different place. So it can work. Secondly, it needs serious enforcement. This doesn't quite answer the question, where has it worked? But I'm actually thinking of when it can work in more instances, where national authorities are very serious to pull back their own personnel for failing what they think they have taught them. Beyond that, it's a question of context and question of relative judgment as to whether you think it works or not. And so to answer your question about whether it has worked, and if so, where, it depends. Because different people will tell you it has worked from their angle, and others will tell you no, it hasn't worked. Depends on which side of the game you're at. I'd like to go back to this idea that I kind of mentioned. This is not normal law or law in a normal context. It is created in an abnormal set of circumstances. And for as long as we redefine that space as the exception, trying to define what an effective application of that rule is, it's almost, in my mind, impossible. I don't know if we can ever agree on IHL working just because of the way it's constructed.
I will say that one challenge that we have in answering a question like this that says, like, point to an example of where this works, is that international law is most visible when it fails. We notice the failures of the UN Charter when Russia invades Ukraine, but we haven't paid attention to the fact that Russia, has not been invading Ukraine up until then, at least. And there are lots of states that are not invading one another. The states are generally observing the prohibition on use of force under Article 2.4. Same thing is true of international humanitarian law. We don't see the times when the strike wasn't taken. What we see is the strike that was taken where lots of civilians were killed. And we all, point to that, and rightly so, as a terrible violation. And as international lawyers, we call that out as a terrible violation. But what we don't see are the cases where a military refrained from taking a strike because they determined that there were too many civilians, or because they recognized that it would violate their obligations under international humanitarian law in various ways. So this is a challenge that international lawyers frequently face. One hint that things may be working, and this follows a bit on what Michael has suggested, is to look at military manuals of states. And almost every state that has a substantial military has a military manual that it's published, that is widely available, where it does lay out in some detail its view of what its obligations are in accordance with international humanitarian law. Obviously, that doesn't tell us that those are being perfectly observed, or that they have all the processes in place to ensure that these are being actually worked down to the ground. But generally speaking, states don't put things into military manuals that they don't at least have some belief that this is the sort of thing they ought to be doing. And so that's at least a hint that things might be working to some degree. I mean, look, I also will say I worked at the U.S. Department of Defense for a year as a lawyer, as special counsel to general counsel. And I saw, on a regular basis where the US is doing its best to abide by international humanitarian law. Have I written lots of law review articles and been extremely critical of the US for the many violations? Yes, completely. That is my job. But I will also say that there are a lot of people working really hard to actually abide by their understanding of what the rules are. I mean, there's lots of things that we can say that are critical of it, but to say that there's an effort to ignore the law or that there isn't an attempt to act in a way that's consistent with the law, I think would be not being fair to the many people who are, in fact, working very hard to do that.
I take the point, and I would never deny the existence of very many decent people who are trying to do what's right. But I want to go back to the point you've made, Oona. I mean, not seeing all the occasions where it actually worked. As you guys were talking about, this is a different kind of law and it applies to a different logic. Let me say it from a non legal person. I trained in surgery. I don't think I would escape saying, oh, well, I killed the patient, but you don't know all the times where I didn't kill the patient. That would probably be an absurd argument and doesn't justify killing the patient. And this is where the narrative becomes convoluted. Because, okay, you don't know all the times where genocide didn't happen and was supported by almost all Western liberal countries unconditionally. It could have happened every year, but we're only having it every decade. The other thing is, it reminded me of a thing I was told when we were talking about prevention in public health. A guy sees a friend sitting on the back of a train and sprinkling pink powder in the air. And he tells him, what on earth are you doing? Why are you sprinkling pink powder in the air? He says, to prevent the attacks of pink elephants. And the guy says, but there aren't any pink elephants. And the friend says, you see, it works. How do we know? Like, as people. And here I'm talking as citizens, but also as people who might be next on the kill list. I mean, I've had family in Syria who have died and were displaced and so on because Assad got away with doing whatever he wants in the middle of political play for 15 years. And the same people who let him do that for 15 years are now deciding who gets and who doesn't get legitimacy. If the law is meant to serve the people as a not entirely badly educated part of that citizenry, I struggle to see how is it logical for us to be told it just is a different thing and leave it for the experts. And there are good guys. All it takes is very few bad guys to screw the whole thing up. So it comes to the question, as humanitarian workers, we're asked to trust it and advocate for it and not go beyond advocating for it into advocating other stuff. How do we deal with that?
I think part of the role of international humanitarian law is to set new norms. So if once reprisal against civilians was legal, once you delegitimize it, you hope to create a new norm that becomes illegal. And I understand your argument against Oona, but I think that there are certain norms that have been internalized by soldiers, by commanders. They don't even know necessarily the legal aspects and the legal nuance to these issues. But there's a certain norm that was created through these kind of legal moves. And I think that is important. I think that there's also a certain contradiction within the law because the law has supposedly a universal element, and then you supposedly are asked to see all humans as humans and not some humans as human and some humans as less human. And that is also important. The fact that that is not internalized by many, many people is a problem, but I think there's at least a promise of universalism that is critical here. But then when you get to the nitty-gritty of the law, and you actually look at the law from a legal perspective and not as a norm perspective, then the problems really begin. The major issue there, I think, with these provisions is that they allow a series of exceptions. And these exceptions become the playground of military lawyers, and military lawyers use these exceptions, and the exceptions exist within the law. So I'm not sure they're even instrumentalizing or perverting the law because the exceptions are there, black letters. They use these exceptions to actually facilitate violence. I would like to also say one last thing, and that is when you look, Oona before mentioned the principle of proportionality and its importance. And the principle of proportionality, just to remind the listeners, is that a military commander must weigh and balance the expected direct military advantage from the attack versus the expected or anticipated harm that the attack will create. Now, it doesn't specify how we're supposed to weigh this. What is considered a harm that is more than an advantage? But that is only one part of the problem of the principle of proportionality. A deeper problem is how the military sees harm, how the lawyers see harm, and how a doctor like yourself, Tamam, would see harm. And each one sees harm very differently. And the military and legal conception of harm is very limited. It starts from a limited perception. And therefore, when the balancing act is created, it is skewed from the very beginning because the military does not see long generational harm that is always the result when attacking a hospital. It does not seek the reverberating harm. And therefore, even if a commander does weigh the proportionality before attacking a hospital, he's not weighing it in a way that I think is adequate because he cannot even see what harm he's creating.
I worked for MSF for a long time, and 10 years ago, the U.S. Armed Forces attacked that hospital in Kunduz in Afghanistan. And it was a very vigorous demand for an independent investigation. And there was an acknowledgement of human errors. We haven't seen the details of the investigation, but it was a consistent campaign on the U.S. government. Then bit later, there was attacks on hospitals by Saudi Arabia and United Arab Emirates in Yemen, and they just denied it. They just said, well, we weren't there. And we still spoke about it reasonably. And then Russia attacked 100 hospitals in Syria in 1 year in 2015. And there was absolute stone-faced denial of even existing Russian air forces in the Syrian space. And we couldn't denounce it because we couldn't prove that those were absolutely Russian planes. And it's almost that the law rewards denial. My lesson learned, if I ever become a military dictator, is whatever you do, just say you didn't do it. And that is exactly what's happening in Gaza now. There's an absolute denial or an absolute pretense. There is Hamas under everything, so we can bomb everything. Is it a problem with the law itself? Or is it a problem with the governance model that is the General Assembly, the Security Council, and others who are tasked with enforcing that law?
Well, I think it's both internal governance and international governance failures. But first, the problem with the law. I think the mention was made of proportionality, which often is perceived as a good thing. But if you look critically at the principle of proportionality, it is a principle of permissibility. It actually allows you to use violence. But then what it doesn't do is actually precisely calibrate when you cross a line. It allows you to make that judgment yourself until others tell you you have crossed it. So I'm not a great fan of the law itself. Secondly, it talks about disabling your opponent. essentially it grants you permission to go and use violence. Where the disability is and where you exceed it is also your judgment. And that's the first thing. Then the next thing about rules of violence, it recognizes tactical advantage, ostensibly to bring the conflict to a close. So whatever advantage you could use, or a reasonable advantage to bring the war to a close. So if you look at the law itself, it's just one complete denial of what it seeks to do. It's badly constructed as far as I'm concerned. There are elements of the law that open too many doors. That's the first point. The second point is about the governance. We have international structures that are just not appropriate. At the point when we reconstructed the international order after the Second World War, we were genuinely motivated to internationalize solutions. The idea, to go back very simply, that had we had those kind of solutions at that level, the German expansion would not have taken place. We could have stopped it. So the lesson was these problems are not local, they are international. And yet, in that very same document, we draw boundaries of sovereignty. And we prioritize these as the key principles of the country. And I understand, speaking from a third world perspective, you can understand, no, this is a shield rather than a sword. But that structure is a failure in itself. And then you have a structure that actually doesn't recognize the damage that the institutional structures do, i.e., the veto power, for example. We know it's probably not the most appropriate thing for the kind of world we live in, and yet we're holding on to it. So the international governance is completely rotten. Then you come to internal governance. It is the liberal system is driven by self-interest, which, by the way, is another of those principles of international law which we have written into our discourse. It's about what is good for me. We have almost immediately contradicted ourselves with the idea that this is about a global solution. No, so that if the United States feels that a particular direction is suitable to be able to suit the United States interests, it will go for it. And it is not wrong in the law as we see it. So internally, it has governance structures that even though tell you, you don't do this, you don't do it, then you create exception. If it is in the United States interest, if it is in our interest, we'll do it. My point, therefore, is that the law as constructed, it's not the best. A lot of very broad generalizations, and I know my colleagues will pick on this, and I do want them to pick on it, because that is where we are talking from. And that's why we are still struggling with this.
Look, I agree with most of what's been said. These problems are clearly significant. The law has all kinds of failures. Proportionality is a mess of a principle. But the question is, what's the alternative? So the principle of proportionality provides, and just again for listeners who may not be as familiar with it as we all are, provides that when you launch an attack which is expected to cause incidental harm to civilians or civilian objects, a state is supposed to consider whether the harm will be excessive in relation to the concrete and direct military advantage anticipated. Now, this seems like, oh my God, this is licensing killing civilians. And in a way, sure it is. That's one way to look at it. But what preceded it, and this is where a historical perspective I think is useful, is that the earlier regulations of war really was just around military necessity. It was just if you could just show that a use of force had a military purpose, if you were aiming at, say, a munitions depot, or you were aiming at communications infrastructure, or you were aiming at transportation that was being used by the military, you didn't have to worry about whether that was going to kill lots of civilians or what impact that was going to have on civilians. Like, that did not matter. That was not something that states were legally required to take account of. If it had any military purpose at all, that was all that mattered. Necessity was what governed. So as broken as the concept of proportionality is, and I completely agree, like it's got all kinds of problems, the main one being that states have to assess for themselves what's excessive. That word excessive is just so loaded. But the question is, as compared to what? What's the alternative? We just go back to necessity. We're kind of fooling ourselves by saying that anybody can assess, excessive. Or do we say, no, like that basic idea is the right one? And so what we need is like greater clarity about what constitutes excessive use of military force, excessive harm to civilians in relation to the concrete and direct military advantage anticipated. We try to work out some of those details. I guess I share many of the frustrations you all are expressing, but okay, then what? So Syria is another good example. You've raised that a couple of times. I mean, Syria is so horrific. I mean, years of civil war, direct attacks on civilians, extraordinary evidence of torture and violence against civilians.
Use of chemical weapons.
Right, gassing the civilians, including children. I mean, all the horrific evidence that we've seen, it's like in clear violation of everything, all international humanitarian law and human rights law. So zero question about that. But one of the challenges there, among other things, was that this was all internal to Syria, although, of course, caused the refugee crisis. So you had one international law, that is UN Charter, providing that states can't use force against another state, even for humanitarian purposes. And then you had this violation of international humanitarian law and human rights law that was happening that was extraordinary violence. And so you have international law kind of fighting against itself. And then the question is, well, do we want to change the law so that states should be able to intervene in those cases? I mean, obviously, Security Council wouldn't authorize it because Russia vetoed all efforts to legally authorize an intervention. Do we want to say states should be able to intervene unilaterally for humanitarian purposes? That's something that should be up perhaps for grabs. But then once you set that in motion, how do you constrain it? How do you limit it? How do you ensure that states are actually going to intervene for what we would consider to be true humanitarian reasons? What's to stop a Putin from using that to justify interventions all over the place, or China to use it?
Not that anything is stopping them now, to be honest.
Well, I mean, whether nothing is stopping them, I don't know. I mean, that's a whole separate conversation, right? But again, the question is, as compared to what? If the law as it is isn't working, what would work? What would be better? What would have a chance of actually better protecting human beings?
And I think this is the legitimate question, because here, this, what you're saying, as opposed to what could be interpreted in two ways, and I'm not judging your intention, is it's the best, worst thing we have, like Thatcher, if I remember, called democracy or something.
Yeah.
Or it could be said, okay, it's not working. What is the better alternative that we can strive for?
Yeah.
And I think that is both in framing it generally, but also in details. And this is where I know, Neve, you want to say something to that, but I also want to bring the effort you're working on, which is, if I understand it right, and you'll explain it better, on never taking protection of health facilities. And this brings it to the humanitarian sector, where the idea of protection is quite crucial, because as I have observed multiple times in Yemen, in Syria and other places, it's not only the people who die in the bombing, it's rendering health facilities unusable because people are scared of going to them. That is indirect death. That is quite morbidity and mortality. That is quite significant, doesn't count in the proportionality argument.
We need to think in a few directions simultaneously. We need to think that just as there was these developments in the law that Oona was talking about, there's also been developments in weaponry. And the lethality of the weapons has changed dramatically. And here we have the first war, I think, that was carried out with AI in Gaza, where tens of thousands of targets were created by a machine learning program that every target was inspected according to the newspapers for 20 seconds by a soldier. So it's a way of thinking of war as becoming a war with no human in the loop almost. Okay, and that's where we're heading. Okay, so we need to understand where we're heading in terms of war and what is the discourse that we have. And is the discourse of regulating that the right discourse, or is the discourse of banning weapons? Should that be the discourse? And very little work is being done on that because the war corporations are so powerful. We need to understand it within the powerful dynamics. So we need to change, I think, what we're looking at. We need to look at the production processes. We need to look at the modes of production. We need to also look at other discourses. I mentioned before the discourse of care. And I think we can think, how do we organize a society from the most intimate to the planetary, and through wars in the middle, that the organizing principle is care. Now, that is a different way of thinking, and it will take years to develop, but we need to start thinking outside the box, and not only do we change this or that comma within the law, or how do we get more countries to acknowledge the law and so forth, because I'm not sure that's going to help us.
So in that stepwise, where we address the inappropriate part of the law and seek to revamp it seriously beyond haggling about the commas, what should we do? What is the role of states so we can push them to do it? And what is the role of civil society, including humanitarian organizations? How can we make a difference between, marching and denouncing and then going home knowing nothing will change?
How can civil society really make a difference? I think explaining the perspective of civil society to the military will be an excellent tool, because one of the biggest things is that each one of these is operating in a different domain, and never the twain shall meet. And a framework where these get to have a conversation or to be able to explain to each other how they see things will be great. The second thing is to begin to understand the purpose of the law we are talking about. Is it on the ethics of care? Are we really caring, or is it on ethics of self-interest? Maybe that's where the difference lies. We need to redefine what the purpose of ever going to violence. And if we take Neve's point that certain things are complete red lines, you will soon find that there are more red lines than blue lines. And if we can begin to understand these red lines, maybe the rules will look like, okay, these are the only few places where you can actually use violence. And then we slowly work it down to the point where, if you are in my way, that's not a tool to use anymore. If we can work our way slowly to the point where we don't need international humanitarian law, then I think we're making progress. But to agree with you, I don't know, it may take 10 years. It may take 100 years, but we should be working at it. The key is to admit that we have a problem with the law as it is. And if we admit that, then the question then becomes, how do we step up to make this change? If we continue to defend the law as it is, we will not move on. And that's what I fear.
I think you also gave a clue in one of your questions. You said, what's the constituency of international humanitarian law? I think we need to rethink the constituency, and that would be the first step. It's obvious to me that we need to broaden it to non-state actors, non-state warring parties. They need to feel that they are part of this process of creating the law, and therefore you will begin bringing to the table people that are positioned differently and look at the law from a different position, and can broaden our horizon of the effects of the law because of their different positionality. So I think we really need to take seriously the constituency, that it's not only state actors. So long it remains as state military actors, it's not going to change anything. I think the first move would be to broaden it to civil society. So, for example, if we're looking at healthcare, then there's safeguarding health in conflict. They need to sit at the table. They come with a different perspective. MSF needs to sit at the table. Doctors that were attacked in military attacks, that understood what it means to be on that side, need to sit at the table. I think that would be a first step too, is broadening the constituency, the subject that it matters to.
I mean, I'm listening to all of this and I find much of it very appealing. I have to be honest that I have a hard time imagining it succeeding. And I'm sorry to be the wet blanket, but again, history may be useful here. I mean, if you read in the interwar period between World War I and World War II, there was so much energy that was going into disarmament. That was really the focus. There were some efforts at regulating war, but really, like, the main thing that states were trying to do was disarm. I mean, there was a critical innovation during this period, I will say, and I've written a whole book about it, which was the prohibition on use of force that was adopted in the 1928 Kellogg's-Briand Pact, which said basically, like, disarmament's never going to work. What we just have to do is outlaw war. And that's, the only option. And honestly, I think they were basically right about that. And that rule then gets incorporated into the UN Charter as a prohibition on use of force. But to the extent that they were debating disarmament, it kind of went nowhere. That's not to say that some limitations can't be adopted. I mean, I think it's pretty clear that prohibitions on cluster munitions have been successful, mostly because they're understood to be inherently in violation of international humanitarian law. The Landmine Convention, which has been mentioned, laser blinding weapons are clearly prohibited under IHL, and you don't see states using them. Chemical weapons are clearly prohibited under the Chemical Weapons Convention, but also under understandings of IHL. So it's not that all limitations on armaments are impossible, because they're not, but that's going to be our way to solve the problem that we're talking about today, I think is just not very likely, just because states are not going to give up all weapons. And if they don't give up all weapons, we're back in this fix. I also will say that while I find appealing the idea of bringing in other actors into the conversation, and in lots of other areas we've seen that in environmental law, for instance, we've seen incorporation of NGOs, even in trade, we see ways in which NGOs and non-state actors are permitted to participate in, say, dispute resolution processes at the WTO. And there's been a lot of incorporation of non-state actors into a variety of areas of law. In the end, it is states that make the law, at least when we're talking about international law. And it's going to be hard, if not impossible, to get states to give that up. I mean, that's the nature of international law. International law is law that's made by states, for states. And so I don't disagree that there's a role for non-state actors, and the non-state actors ought to play a role, certainly in enforcement and in helping us think creatively about the law. But in the end, you're going to have to persuade states if you want it to be international law. Now, again, we may decide to give up on international law as a tool, but as long as we're talking about international law as a tool, that is made by states. And states are hard to persuade to give up the right to use force unless everybody else is willing to do it, and nobody else is willing to do it. And so kind of getting that going is just extraordinarily challenging, which leads me to, we're focusing primarily on international humanitarian law here. The one big success, the thing that has actually worked, is an effort to try and limit it when it is legitimate to resort to force at all. Not been perfect. We're obviously seeing lots of cases where this has been tested and violated. But that said, the prohibition on use of force in the UN Charter, first in the Kellogg's-Briand Pact and then in the Charter, has actually been pretty darn successful. And, we're at a moment, though, where that is starting to collapse. We're at a moment where you've got 3 of the P5 members of the UN Charter either threatening or using force in violation of Article 2.4. And that is the real crisis. I mean, not that these other things aren't crises as well, but that could lead to real catastrophe, because once you uncork the idea that states can legitimately resort to force to address their various grievances, the problems we're talking about here, I think, are going to be dwarfed by the violence that we'll see unleashed. And then we'll all kind of wish we were hearkening back to these quote unquote peaceful times. Not that these aren't critical issues, but I think let's not lose sight of the fact that really, in a way, the critical question is whether states can resort to force in the first place.
So the constituency is not the people, it is the states and the state interest. And it's not the most common thing for the state to honestly reflect the interest of it, even if its own people. And to go back, when we say we've created the system after the World War II, I mean, I'm out of that. We were under colonial rule, we didn't create anything. Although arguably, there have been better times. We've interviewed a historian here on the show that has talked to us about his grandfather, actually, Thant Myint Oo, whose grandfather was the first non-white person to be the Secretary General of the UN, U Thant, in the 60s. And there were still spaces for negotiation to potentially not have war, or it felt like it. That doesn't exist now as much.
But Tamam, both you and Oona, you're asking us to think of alternative, a new horizon. But then at the same time, you're reasserting the borders that create the horizon we live in.
I agree.
And you're saying that is beyond the question. We can't talk of a broader constituency. And part of the problem of birth of this legal order, as the 1977 additional protocols intimate in one article, the problem of birth is the constituency, that the states don't even want to listen, not to say give up their right to decide about the legislation. They don't even want to listen to the non-state actors they're fighting against. They're not willing to sit at the same table as the non-state actors they're fighting with. And that needs to change. If we want to think of a different horizon, we need to think outside the box. And we can't come back to the rules that are constraining us from thinking outside the box.
I want to follow on that because as much as I distrust states to have the interests of people at heart, it comes to what is the cost of adhering to an argument where it is a law for states and states are the only ones who are. When we are witnessing not only a few rogue states enacting genocidal wars, or a few powerful states expanding the definition of war into a global war where, can hit anyone with drones anywhere in the world. And we're lucky we're still having the human in loop. It's not ChatGPT that decides who gets to live and die. So at least there is a trace of humanity in that decision on proportionality and otherwise. But at what cost do we adhere to the idea? We have seen two things. One, Neve, you alluded to, is the crisis of liberalism. And the way I put it, not being very fond of liberalism is liberalism used to pretend to care about others and that everybody's life is equal. And humanitarianism was one of the byproducts of that pretense. We will give you the ability to save some lives. You stay apolitical and give us, moral justification for doing our wars. That stopped being the case. The US has $1 trillion on weapons and a complete disregard of any limitation, even in lip service. Germany is changing the constitution so they can go in debt and buy weapons. Now, the cuts on humanitarian aid is under the argument of needing weapons. Defensive, arguably, but who knows? The liberal order under which there is a possibility for both humanitarianism to exist and for the law to be applicable is going away. That scares me. The other one is if our argument, as you're alluding, Neve, is states are the conduit of change, so we need to convince the states, but the states don't want to be convinced. We've seen millions of people march in opposition to their states in defense of Palestine. And there is a boiling point where we are throwing not only the baby and the bathwater, but the tub as well. If we continue to ignore the fact that there is a non-constituency, which is the citizens of the world, that is actually unhappy with this. So far from demanding this, we stick to the box we're in. I think we should go as far as we can. But what is it that we can do? So if our listeners sat here and said, all that is good and fine, there's a range of actions that go from lobbying Congress or a parliament to change their position, pressuring the EU institutions, and trying to change things to the better, all the way to changing the very underlying moral conception of the law and what's right and wrong. what can we do? What should we get out of this? And say that, this is something as a humanitarian organization or as individuals who are involved with it, I can do as of tomorrow.
I can say one brief thing that is not going to be a complete answer at all, but maybe in the direction of an answer. One powerful mechanism that is in the Geneva Conventions for enforcement that has been underutilized, well, there are two. One is decentralized criminal enforcement of the prohibitions in the Geneva Conventions. So conventions require that states not only prosecute their own soldiers who violate international humanitarian law, but that if there are those present in their jurisdiction that are known to have violated international humanitarian law, they have an obligation to criminally prosecute them. And you've seen some bits and pieces of this to the extent that there's been any accountability for war crimes and crimes against humanity that were committed in Syria, which we've talked about. That has actually happened through criminal law enforcement in European states, where people have fled as refugees and then been identified as war criminals, as people who violated international human rights law and have been prosecuted in courts in Switzerland and Germany and other European states where they've been found. There have just been a few of these cases, but this is a mechanism that's available that is maybe underutilized. We've also seen threats, although not actual prosecutions, of Israeli soldiers when they've been traveling on vacation. They've had to quickly leave some states where it's been clear they're about to be prosecuted for war crimes. So this decentralized criminal law enforcement is, I think, a powerful tool that has not really been used, and states could be encouraged to look for ways to use that more fully. The other mechanism that's built into IHL is a requirement that states not only respect the Geneva Conventions, but quote unquote ensure respect for the Geneva Conventions. And this is in Common Article 1 of the Geneva Conventions. And that, I think, is properly understood to put an affirmative obligation on states to not only not support violations of international humanitarian law, but to respond to violations with affirmative sanctions. And you've seen some little inklings of response to this obligation. So Germany, where I am right now, has cut off arms sales to Israel because there was a determination that they couldn't be sure that they wouldn't be used in violation of international humanitarian law. Netherlands similarly prohibited sales of F-35 parts to Israel for similar reasons. Now, these are, again, just bits and pieces of an attempt at a response, interpretation by these states that they have this obligation not to enable violations of international humanitarian law. But these show a path forward of things that states could do. And, listeners who are concerned about this could press their states to take more action themselves. They don't have to wait for others to do it. Their own governments can take action where they see these violations taking place.
I think one of the biggest suggestions, which I think came from Neve, is for us to acknowledge what we have and to also acknowledge that what we have has shortcomings. And therefore, if we're going to have solutions, to step beyond that. And so I'm going to make a little bit of an exaggerated but fairly brave statement. I think the whole concept of statehood is an exaggerated concept. We need to ask ourselves whether we really need these states to represent us. And therefore, the question is, what can individuals do is to challenge these states if and when they think they are not being represented. The idea of we do this in national self-interest. Well, if you feel strongly that killing civilians in another country is not in your interest, you ought to be able to challenge the state at that point. And I think they need to be able to step up regularly and consistently, letting the state know that this may be of interest to the elite, but it's not in my interest. And the more of that we hear, the more the states will probably begin to look back. And maybe, only maybe, Neve's point may come alive where at some point, because they're having so much challenge, they probably will only take the step after they've heard from the constituency that's being removed, i.e. the civil society. Because I too believe that that conversation needs to be had much more widely.
I'll just say, empirically, the states are the actors that exert the most violence against civilians in wars around the world by far. It's incomparable to non-state actors. We have a situation where the violator of international law is also the creator of international law and also the protector against the violation of international law, which is a contradiction in many ways, or at least a serious tension. And we need to overcome that. And to overcome that is we need to decenter the state in this whole apparatus. And that should be on our agenda, and that should be part of the conversation, at least. How do we decenter the state? When ICRC creates working groups to bring together state militaries to think if they need to redraft the laws of war, they need to invite to the table other people. We need to start decentralizing the state because it can't be that those that exert the most violence are those also responsible for the laws and for upholding the laws.
Thank you very much. I'm extremely grateful for your time.
Thanks
Thank
to
you.
everyone.
Thank you.
Thank you for listening to Rethinking Humanitarianism. Our show is produced, edited, and mixed by Levi Sharp. Editorial oversight provided by Erwin Loy, Eric Reddy, and Freddie Buswell. If you have any questions or comments, you can email us at podcast@thenewhumanitarian.org. Please rate and subscribe to our show wherever you get your podcasts. Also, consider becoming a member of The New Humanitarian to help us continue reporting from the heart of crises. Go to www.thenewhumanitarian.org to find out more.